This is All India Radio. In the program Spotlight, now we bring you a discussion on new IT rules on fact-checking and online gaming with RAJEEV Chandrasekhar, Union Minister of State for Electronics and Information Technology. The discussion is moderated by Kanchan Gupta, Senior Advisor to the Ministry of Information and Broadcasting.
We have with us Minister of State for Information Technology, RAJEEV Chandrasekhar, who has been basically piloting the amendments to the IT Rules 2021. This is the second lot of amendments. These are essentially to do with online gaming and a new aspect which has been introduced, that is, government will be fact-checking information about the government, its various agencies, which is posted on social media platforms. And they will be fact-checked for whether it is fake news, whether it is malicious disinformation, and whether it is misleading reportage. The government will then take the next step of actioning itself against these posts. Thank you very much, Minister, for joining us today. Can you briefly telling us first what are the amendments that pertain to online gaming? And then I will come to the part about fact-checking.
The premise of these amended IT rules is a continuation of what we laid out in October 2022, which is that intermediaries and social media intermediaries in particular have obligations vis-a-vis certain types of content. And to help fulfill those obligations in these rules, we have created a fact-checking unit which will essentially flag information as fact, fake or false or not. Now, beyond that, the government has not given itself any other powers in these rules to take down. Whatever takedown powers are there arise from the IT Act and the rules which are to do with Section 69, and there have been no changes in that at all. These rules deal with two issues. One, of course, the very important issue of online gaming. And online gaming, as you know, is a very exciting, very fast-growing, expanding part of the overall innovation ecosystem. It is certainly, by any stretch of imagination, an extremely exciting area for startups and investments and creativity for the coming years, and has been for some months and years now plagued with all kinds of legal interpretations, many courts giving orders, many states enacting rules, regulations, guidelines, and as we saw recently, Tamil Nadu enacting its own law, creating essentially a regulatory minefield of uncertainty, ambiguity, confusion, etc., etc. So these rules essentially lay out a very clear, crystal framework, establish principles, and create institutional capacity through SROs to further develop regulatory maturity and regulatory direction as we go forward. In essence, however, the fundamental principle, which is consistent with our overall framework to make sure that the internet is safe and trusted, and therefore to mitigate user harm, is that we have identified betting and wagering as the user harm that will not be permitted on the internet. And when we start with that basic principle that user harm should include betting and wagering, and that is therefore a no-go area for platforms and intermediaries, it follows very simply from there that online gaming of all types therefore are permitted online on the Indian internet, excepting for those that are real money and that pass the test of real money and wagering, or real money and addiction, on real money and user harm for children. So therefore, the basic principles of what online gaming is permitted have been established. The internet, as you know, Kanchan, cannot be regulated by states. So therefore, in a lot of ways, it's meaningless for a state government to try and legislate for things that are happening on the internet, because it's certainly something that they can't do very much about, even if they have a law and order under their control for the state. So these rules, in my opinion, create a framework that now is clear for all states, all courts, and the most important stakeholders, the gaming startups, the gaming companies, the gamers, about what is permitted online and what is not. So I think this is a good first step for the online gaming industry, the online gaming ecosystem.
When you are prohibiting online betting and wagering, how does it override the state's authority, or is it in conjunction with it? Is this just a regulatory architecture which the states can or should follow? And lastly, now when you have something like Tamil Nadu coming up with its own law, how do we reconcile? Because I'm sure other states will also do that, states which allow online lottery. How will we reconciling the difference between the prescription in the IT rules and what the state governments wish to do.
Betting and gambling are the same thing, and yes, some states allow it, some states don't allow it. So, for example, betting is fine in Goa, is not fine in Tamil Nadu, Karnataka, Kerala, and many other states, including the states in the north. So, this is not in any way an attempt to regulate betting and gambling as is happening or has happened and is being regulated by the state and their law and order machinery. They are prohibited in most states. And when somebody does betting and is caught doing betting, they foul of the criminal law and cases are filed by the local police and are prosecuted. So that continues unchecked. That continues as is continuing now. The issues about the internet and activities on the internet. Now, certainly it is clear, even to somebody who's sort of looking at this very commonsensically, that the internet is not a state subject and the internet can never be regulated by a state. Even countries are having difficulties in regulating the internet because of so much of the borderless nature of cyberspace. So these rules, what they do is to say what can be done on the internet and what cannot be done on the internet. That power rests with the government of India via the IT Act and in the future with its successor act, the Digital India Act. And under the IT Act, we are today saying that on the Indian internet, anything that is wagering is a no-go area for an intermediary or a platform. It's as simple, and some people have told me that but this is remarkably simple, but it is as simple as that. Now, will this come into conflict with some states that are trying to look at gaming from games of chance, games of skill? For example, the Tamil Nadu Act, really, in my opinion, and with no disrespect to the government of Tamil Nadu, is a bit of a lost because it's making all these complex nuances about games of chance and games of skill, which is really not the issue today because betting is defined by whether there is a wagering on the outcome of a game. Whether that game is a game of skill or a game of chance does not matter. So it's a question of, I think some states and some organizations and some lawyers have created certainly a tremendous amount of confusion, maybe deliberately, maybe not so deliberate, and have made this a lot more complicated than it should be. We are about addressing user harm on the internet. We are about addressing illegalities on the internet. We certainly want the Indian internet to be open, safe and trusted and accountable. And therefore, one of the issues that impinge on safety and trust is the issue of online betting. So we have regulated online betting as not permissible in the Indian context on the Indian internet. Simple as that. Now, if some state governments want to do something more than that or less than that, they certainly can't do anything less than that. But if they want to say like, look, as a gamer in the state of X state, we also don't want you to do A, B, C, D, and that will foul of our local laws. They are free to do that.
There is another issue, advertising for online betting and wagering. Now, till now, Government of India could only issue advisories against such advertising because there was no overall architecture. Plus, the reason was that some states permitted lottery, online gaming, and some didn't. So now that this new architecture is in place, will this also mean a total stop to either direct or disguised advertising promoting online betting and wagering?
I certainly think yes, that if something is not permitted on the Indian internet, we certainly cannot have platforms domiciled in the British Virgin Islands or Cayman Islands advertising those platforms on the Indian internet. For what purpose? I mean, if it's an illegal service, why would an illegal service want to advertise in India unless they say we will provide you a loophole to avail our services? I mean, it makes no sense if somebody says, no, I still want to advertise. I'm a betting site. I'm based in whatever, but I want to be able to advertise on Indian platforms and Indian media, even though my service is illegal. It makes no sense. So we have in the rules prescribed that no advertising, surrogate or otherwise, of these online gaming services that contravene the conditions of either wagering or addictive behavior and or harm should be permitted.
So now let's move on to the big issue about fact-checking. We know the thrust and trend of the criticism. A lot of it is being fueled by so-called free and open internet activists. We know why they are canvassing against this part of the amended rules. There is also an attempt by some media organizations like the Editors Guild of India, etc., saying that this will have a chilling effect on media and it will restrict press freedom. And soon we will hear that this is the latest assault on democracy in India and this restricts democracy and this directly hit free speech. And yet, although it has been available in the public domain, both the draft as well as the actual amendment.
Let's be clear, Kanchan. I just want to first share with you how the rules work and how they worked before these amendments and how they will work after these amendments. When we enacted the IT rules, again after significant consultation, September, October of last year, the impact of that was very simple, that social media intermediaries, and this was mainly to do with social media intermediaries, under Rule 3 had a higher degree of due diligence that they had to perform vis-a-vis the content that they host if they were to qualify for the Section 79 immunity that was given to them in 2008, which was a free pass for social media intermediaries from anybody who was aggrieved by content on their platforms and wanted to sue them or wanted to legally challenge them. This happened in the last IT rules, like I said, September, October 2022 rules. And there were 9 categories of content under 31B5. And those were CSAM, religious incitement content, patent violations, misinformation or patently false information. And there were 9 categories of content for which the intermediaries needed to do more due diligence. And under 32B, if I recall correctly, even if they missed the content, if it was reported to them and the content fell under 1 to 9, they had an obligation to take that content down if they were to continue to be enjoying the Section 79 immunity safe harbor vis-a-vis those who were aggrieved by that content. This was well understood, well accepted. It is a partnership between the intermediaries and the government and the stakeholders, including Nagriks who use the internet, to best essentially make sure that misinformation and the other 8 types of content that represented a challenge to the safety and trust of those who use the internet were dealt with in a responsible manner, in a consistent manner. A large part of the misinformation operations have always been directed against the government. I'll get into some more detail about what is misinformation and why are we so concerned about misinformation down the road. But misinformation operations have been large part directed at the government and are becoming even more difficult to obviously determine. There are deep fakes, there is misinformation, there is anonymous accounts posting data and facts about government. There was a Washington Post story recently by John Menn who talked about these Khalistani bots and accounts that were posting fake information about the government and including incitement to violence as a consequence of that fake information. So misinformation directed at government needed to be addressed.
Recently, there have been reports that the German Justice Ministry, they are in the process of penalizing Twitter and imposing a fine of $60 million for not responding to their pointing out that these posts or these messages which were posted were defamatory, they were hateful, they were targeted against individuals, and yet nothing was done. So it's not as if that we have discovered the wheel. The wheel is there and the wheel is being used with a pretty strong hand by liberal democracies in the West.
The IT rules do not envisage any punitive consequences of an intermediary if they violate the rules. We are actually only saying today, let's say you are an intermediary and you think you're very big and you don't need to follow any of the obligations that we have cast in the rules. The only consequence to them today is, it is an important consequence, but the consequence is not financial, not criminal. It is a consequence that the Rule 7 will kick in, which is that the safe harbor under Section 79, which has essentially made them what they are today, these platforms with no responsibility, no accountability over the last decade, that safe harbor falls. And the moment the safe harbor falls, they are therefore then subject to any case that is filed against them, criminal, civil, for financial penalties, etc., from a government department, the police, the individual who's aggrieved in this matter, etc., etc. You are absolutely right. The war against misinformation, this effort to deny misinformation space on the internet is a serious effort that is now being undertaken by countries all over the world. The G20 Bali Declaration talked about how disinformation and misinformation, we need a global response to it.
Thank you, Minister. Thank you for this excellent session.
Thank you.
You were listening to a discussion on new IT rules on fact-checking and online gaming with RAJEEV Chandrasekhar, Union Minister of State for Electronics and Information Technology. The discussion was moderated by Kanchan Gupta, Senior Advisor to the Ministry of Information and Broadcasting. You can listen to it on a mobile app, News on AIR.